All right, let's get started. Good evening and welcome to the San Marino City Club February meeting. Typically, this is a dinner meeting, but I'm sorry to say you're on your own for that tonight. I am Pete Leffler, your 2024 San Marino City Club president, and I haven't emceed a meeting like this in 12 years. So you're going to have to bear with me if I make a few mistakes. And if I do, you can certainly jump in and say something. If you would, click your mute buttons, lower left-hand corner, please, tonight. We get feedback on these meetings sometimes from different things around people's venue where they are attending the meeting. So if you'd click that, unless you need to speak. And if you do need to speak, there's a button at the bottom of the screen called Reactions. And you can click a hand on there and we will acknowledge you. Also, this meeting is being recorded tonight, so please keep that in mind as well. All right, let's begin the evening with recognizing the colors. Bruno, please post the colors. If you would all stand with me and repeat the Pledge of Allegiance, I would appreciate it. I pledge allegiance to the United States. Boy, what a way to start. All right, done this 100,000 times in my life. I pledge allegiance to the United States of America. Oh my goodness, that is crazy. All right, somebody help me out here. Get started on
I got you, Pete. I got you, Pete. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God,
indivisible,
with
justice
liberty
for all.
and justice for all.
Justice for all.
Thank you. Wow. I think at least 100 times in my lifetime I've done that, and that's odd. Let's go to the next one. Next slide, please. All right, I've got a few introductions tonight. This is your list of past presidents. Go ahead, click one slide. This is your past presidents that I won't acknowledge all of you tonight, but a number of you are on the have registered for the meeting tonight, so that's terrific. Thank you. Next slide. San Marino City Club Board. A few of you are also on the meeting tonight. A couple of you are on vacation, and I appreciate the fact that you're also logged on. That's terrific. Thank you. Go ahead, next. All right, and tonight we have with us no members of the City Council that I'm aware of that registered, but I will say with all of the city personnel, from the City Council to directors in the city, to other personnel, I thank you for being part of City Club and for the support that the city gives City Club. Next slide, please. Tonight we have Philip Escondar, our city manager, is with us. John Encontro, police chief. Mario Rueda, police fire chief, have all registered. Kathy Johnson is on or registered tonight for Community Services Director. And we also have Nicole Tibbett, Community Engagement Manager, on tonight or have registered. Thank you. And of course, we have Shelley Ryan, who is the president of the Unified School District. We probably have the first man who is also a past president in Kelly Ryan on tonight, my guess. We have Joseph has registered. Joseph Chang, vice president. Thank you. Next slide. And on the Unified School District tonight, we have registered Linda De La Torre. Welcome, Linda. And Stephen Choi, if he's made it. Stephen is actually on vacation, but has been a great help in getting me prepared for the meeting tonight. So thank you, Stephen. All right, next slide. Okay, back up one. Welcome new guests. There are no new guests tonight or members tonight that we're going to welcome. Part of that is because of the position of the club and where we've been the last few months, but I'm looking forward to next month being able to welcome new guests and club members. With that in mind, I announced to the club last Tuesday and Thursday night at the meeting that we're going live in person with the April meeting at the Huntington, in which I would love to be able to welcome new members and guests at that meeting. So please keep it in mind. Okay, next screen. Tonight, our feature speaker, Kristine Kwong, who you heard interacting with me a few moments ago. Thank you, Kristine. Kristine is a trustee on the Pasadena City College Board of Directors. She is also an attorney. She specializes in court cases affecting employers in California, namely issues relating to sick leave, leaves for reproductive loss, and court cases involving wage rules and employment practices. Kristine, this should prove to be an interesting meeting tonight. I'm looking forward to it. And let's get started. Kristine?
Great. Thank you so much, Pete. It was always a pleasure to come here, and thank you so much for inviting me. I am now going to switch over to my presentation. So I just want to check everybody can see the slides. Is that correct?
I can, thank you.
Okay, very good. Tonight's presentation is the 2024 legal update, and the focus is on new legislation that relates to employers. And also, I will be following up on some of the more significant case law that has been decided by our California Supreme Court, as well as our California Court of Appeals. As you know, cases decided by our Supreme Court and the Court of Appeals actually become law for our employers, and we need to comply with them. So I'm going to first start off with some of the new laws that Sacramento passed that are going to affect you as an employer. So one of the biggest pieces of legislation is that we now have an increase in paid sick leave. So as you recall, a few years ago, many years ago, sick leave was an employer fringe benefit, which means the employer can give it out as a benefit, and they can also choose not to provide sick leave as a benefit. About 5 years ago, California passed for the very first time a mandatory statutory sick leave law that then mandated mandatory sick leave. And back then, the governor only mandated sick leave of either 24 hours or 3 days. And there were 2 ways you could mandate this sick leave. The first is you can just front load 24 hours at the beginning of the year, which means the employee did not have to earn it. So at the beginning of the year, you can choose January, you just front load 24 hours and the employee can use it. If you use the accrual method, that was the second formula, you can accrue sick leave at 1 hour for every 30 hours worked. So a full-time job is about 160 hours. That's 3 or 4 days of sick leave. Now in 2024, Sacramento has now increased this mandatory sick leave to 40 hours or 5 days. And what you can do to comply with this law is, if you don't like to do a formula because you don't have the human resources to do the calculation to have a formula, you can just front load the sick leave. So you, starting January 1st, I know we're already in February, so you do need to make sure that you front load the entire amount of 40 hours. And then they can use it, meaning they never worked for it. You just give it to them. And you can carry it over. So if they don't use the entire 40 hours in this year, you can carry it over to the next year. And the law allows you to establish a cap of 80 hours, which is about 2 weeks. So the great thing about the cap is you do not risk the employer or the employee accumulating, like some of my staff, over 1,000 hours of sick leave, because we don't have a cap. We let them continue accruing. And so they have over 1,000 hours of sick leave. If you are going to do the accrual method, then you have to offer the 24 hours of sick leave by the 120th calendar day, and then at least 4 hours by the 200th calendar day. So that's the key. So what do you need to do? Well, for those of you, as you know, every single year, well, not every single year, but you go to the Cal Chamber and you buy a new poster and you have to post it in a lunchroom. You post the new posting on sick leave. If you have a handbook, you now need to update your handbook. But here's the most critical part. Your paycheck stub that you give your employees, you must have the sick leave accrual in your paycheck stub. And if you do not have the sick leave accrual in the paycheck stub, that alone is a paycheck violation that you can then be sued for. So having accurate sick leave information on a paycheck stub is very important. So that is the key. Okay. Another new statute that came into effect in 2024 is SB 497. And this is a presumption of retaliation relating to wages. So under California labor law, we have 3 labor code sections that deal with wage complaints and wage theft. And if you are complaining about wages and the employer retaliates against you, these labor codes allow you to sue the employer for retaliation for complaining about, let's say you didn't get paid your overtime, you were underpaid, even your paycheck stub. If it doesn't have your sick leave, you can make a complaint. What this law is now saying is, if you discipline an employee, whether it's a demotion, a suspension, or you terminate them within 90 days from the time they complain to you about their wages, you are now under a presumption that you retaliated against the employee. And the penalty is $10,000 per employee for each violation. It also prohibits you from retaliating against their family member that has a perception that they also filed a wage complaint. So this is actually a very critical new statute, because what the law is basically saying is, if you write somebody up within 90 days from the time they complain to you about how they're being underpaid or they weren't paid their overtime, they can now sue you in court, and there's going to be a presumption that you retaliated, and the penalty is now $10,000 for each time. So the number one question I get is, what do we do now? Are we not allowed to discipline employees? How do we rebut this presumption? Well, you can rebut this presumption by showing that there were legitimate reasons as to why you disciplined that employee. How do you do that? You do it by having a very well documented file on that employee. What that really translates into is you have to start writing people up as soon as possible and having a good paper trail. So by the time you have to terminate somebody, it is not a surprise and you have a good paper trail leading up to it. I encourage employers to keep what's called a supervisor's journal, meaning if you see an employee doing something that's not appropriate, you write it down in a journal. And then after they do it 2 or 3 times, then you do what I call progressive discipline, which is the oral reprimand. And if they repeat it, you now go through the steps of progressive discipline, which means you went from an oral to a written reprimand to a letter of warning to a suspension and all the way to discharge. So if you have a nice record of progressive discipline, that will actually be your best defense if you get a claim like this. So that's the key. Having a good paper trail is the key. This next area of new legislation is SB 700, and it deals with cannabis use. So let's kind of go through the history of marijuana in California. As you know, marijuana used to be illegal. In fact, you can go to prison for possessing or using marijuana. Then about 7 or 8 years ago, we passed legislation that legalized medicinal marijuana. So if you had a prescription that allowed you to use cannabis for a medical condition, that was perfectly lawful. We still made it illegal to have recreational marijuana. But then about 3 or 4 years ago, we passed a statute that has now made it legal to consume marijuana on a recreational basis. So it is now legal. In fact, there are laws that allow you to grow marijuana plants in your home. However, cities have been passing ordinances regulating the operation of businesses that sell cannabis. So that's a big subject of litigation in some cities. So how does that affect you as an employer? As an employer, you can still have a policy that prohibits an employee from coming to work under the influence of marijuana, and you can still have a policy that prohibits people from consuming marijuana at work. So think of it as alcohol or smoking. Alcohol and smoking is legal, marijuana is legal, but you can have a rule that you are not allowed to consume those substances in the workplace. However, a lot of employers are still doing what's called pre-employment drug testing, meaning before you receive an offer of employment, we will condition the offer on passing a drug test. And marijuana can stay in your system for a long time, like 2 to 3 weeks. So even though the applicant, by the time they take their drug test, even though they're not currently taking recreational marijuana, cannabis, once it's metabolized, it will stay in your system for 2 to 3 weeks. And your drug testing might be able to detect marijuana. And then the employer will rescind the conditional offer of employment because it showed up in a drug test. So with that said, what's the new law? The new law is you may no longer discriminate against an applicant because they are using cannabis off the job and away from work. So you can prohibit it at work. You can no longer discriminate against the employee or applicant because they're doing it away from work. And if you send that employee out for drug testing, you may now no longer use a test that will test for non-psychoactive cannabis metabolites. It took me a while to practice to say that, by the way. So what is non-psychoactive cannabis metabolites? That is cannabis, once it metabolizes, it will stay in your system. It does not affect you. This is why it is non-psychoactive. The law now prohibits you from using any type of drug testing where the lab is now testing for this non-psychoactive cannabis, which means, by the way, the types of tests that test for non-psychoactive cannabis is urine testing, and I think hair testing. Those tests are very sensitive, and it can detect this metabolized marijuana that was used recreationally. In fact, I had a school district that contacted me, and they sent this applicant for pre-employment drug testing, and it came back as positive for cannabis. And I said, what kind of test did you use? And they said, we use urine testing. I said, you know what? There's this new law. You can no longer use urine testing. So blood testing will not test for this non-psychoactive cannabis. So starting in 2024, you may only be permitted to take actions against an employee for on-the-job premises use for cannabis and for being under the influence of cannabis, but not off duty. So you need to keep that in mind. Unless you are a federal employee, for example, if you are a Department of Transportation employee, there are certain federal jobs where you're just absolutely not allowed to consume cannabis. I assume most of you are not in those positions, but if you drive a 18-wheel truck or you work for the federal government, for the DEA, they can still test for cannabis. So that's the key. This next statute is SB 848. This is employment leave for reproductive loss. You're probably wondering, what is that? Well, if you have 5 or more employees and you worked at least 30 days for your employer by law has to give you at least 5 days of unpaid leave for a, quote, reproductive loss event, and it must be taken within 3 months. So what is a reproductive loss event? It is a stillbirth. It is a miscarriage. It is you try to adopt a child and you fail, which means men are eligible for this leave. Surrogacy, you try to get medical treatment for reproduction and it failed. That is a reproductive loss event, and the employer now has to provide 5 days. And you're probably thinking, and by the way, the maximum is 20 days. So I'm going to ask you this question. Is it possible to have a miscarriage more than once in 1 year? And the answer should be yes, it is possible. So this leave is actually 5 days per event. So you might have an employee that might suffer a reproductive loss several times per year, and each event affords them 5 days of an unpaid leave. So keep that in mind. It is not once a year. And you're probably wondering, why did the government come up with this new leave? I'll tell you why. First of all, if you try to adopt a child and you failed, and now you're depressed and you want to take some time off, first of all, your sick leave will not cover you because you are not sick. So you can't take sick leave. You then have family medical leave. That's called FEMLA. You get 12 weeks of FEMLA leave. But in order to qualify, you need to suffer from a serious medical condition, which requires hospitalization. So you might not need hospitalization because you're sad based on a reproductive loss. So that really only gives you vacation time. And an employer by law can deny you vacation leave, or you take a leave of absence without pay, but that still requires the employer to grant that leave. They can say no. So this reproductive leave actually fills a void that sick leave, vacation, and FEMLA does not provide. So what do? If you have an employee handbook, you need to update your employee handbook. If you have an employee that calls out saying, I'm not going to come in today, and then you find out they had a miscarriage, well, do not automatically use their sick leave or their vacation time. If you find out that it's a reproductive loss, in your books, you need to exhaust their 5 days of reproductive loss leaves. So that's the key. You don't want to exhaust sick and vacation, and then they run out, and then now you're ready to terminate them because they don't have any leave left. So you have to be very careful about that. So this next slide deals with arbitration agreements called AB 51. What is AB 51? Well, a few years ago, California passed AB 51. And AB 51 was a statute that made it illegal to have arbitration provisions for an employer. And that got litigated all the way up to California. Then it got appealed to the United States Supreme Court. And finally, the Supreme Court said, California, you are not allowed to enforce AB 51. It is illegal. So what does that mean? I feel like I'm going to talk in two negatives now. It means California cannot have a law banning employment arbitration agreements. So as an employer, that helps you. So currently, you may still require mandatory arbitration agreements as a condition for employment. Why would you want that? Because you want to get away from a jury. A jury, in our legal field, we call them runaway juries, where they can get out of control and render a judgment of more than $1 million because they want to. With an arbitration agreement, your case never goes in front of a judge or a jury. It goes to an arbitrator, and it prevents these runaway jury verdicts. So if you hear about these huge jury verdicts where an employee gets $40 million, it's because of a runaway jury. So you can still have arbitration agreements. Keep in mind, the federal government passed a statute where they carved out sexual harassment claims from arbitration. So if you have an employee that has a sexual harassment case, they do not need to go to arbitration. They can still go to a court of law for sexual harassment cases. So that's the key. Okay. I have about 15 minutes left, and I wanted to go over some new case law. These are cases that was decided by the California Supreme Court and the Court of Appeal. So this first one is called Garcia versus Cola. And remember how I said a few slides ago, there's a labor code provision that it makes it illegal to retaliate against an employee when they complain about not being paid their wages, for example. And the new law says if you terminate them within 90 days, there's a presumption of retaliation. So that was one of the second statutes in the beginning. Now, here's a case. And the issue is, can an employee sue you for retaliation for complaining about unpaid wages when the employer actually knew that they were violating the law? So how can you blow the whistle by disclosing something to an employer when the employer says, you're not telling me anything new. We knew we were violating the law. So what's the case here? The employee complained to the employer that, hey, I wasn't getting paid for all the hours that I was worked. What does the employer do? They threaten to call immigration, and then they threaten to terminate. This is your classic whistleblower lawsuit. And when they sued, the employer said, you're not blowing the whistle. We know we didn't pay you your wages, so there's really nothing to blow. And the Court of Appeal says, you're right, employer. If the employer already knew that you're violating the law, there's really nothing for you to report. So there you go. That was a win for the employer. Went up to the Supreme Court in California. Supreme Court said, I don't think so. And they reversed it. And they said, It does not matter that the employer knew that they were violating the law, as long as you retaliated against the employee for complaining to you, that's all that matters. It does not matter that you already knew. So what does this go to? When this employer terminated this employee, we want it to be on a legitimate work-related reason as your defense. And this is why keeping a supervisor's journal is so important, and why imposing progressive discipline is so important. If this employer did that, and they had a long documented history of performance issues, it would be a different outcome. Except in this case, they also threatened to call immigration. So that's not a good fact. So let's not do that. This next case is called Camp versus Home Depot. So Camp versus Home Depot is a case that deals with rounding. So I'm going to assume that a lot of employers here have hourly employees. So you pay them by the hour, and you pay them by the hour, and they are required to keep a time record. And employers keep their time records, hopefully 2 ways. The first way is the employee writes it on a time card. So they write in 8:59, they come in, and then when they leave for the day, they write on a piece of paper, let's say 5:05. That's one way. A second way is you actually have a time clock, and there's a time card, and the employee, when they come into work, they clock in, and then when they go out, they clock out. So this case deals with the whole issue of rounding. So what's rounding? Rounding is when the employer rounds the employee's time. And what that means is if I come to work at 8, let's say 9:02, the employer just rounds it to 9. And then when they leave at 5:05, they round it to 5. So at the end of the day, they're paid for, let's say, 7 hours with a 1-hour lunch. So they're paid 7 hours. But in reality, the employee actually worked for 7 minutes without compensation. I know all of you are thinking the math right now. You worked for 7 minutes. And there's a Supreme Court case called See's Candy, and See's Candy says that is legal. You are allowed to round as long as you're fair. So if I look at your time cards over a 1-month period, sometimes the employee gave you free minutes, like 7 minutes. And then on other days, you gave them free minutes, meaning they clocked in at, let's say, 8:59, or let's say 9:05 or 9:07. So they came to work 7 minutes late, and you paid them starting from 9 o'clock. So you gave them free time, they gave you free time. So let's take a look at this Home Depot case. This was a huge, huge class action case nationwide. And this guy, Camp, he figured out that over 4.5 years, he was underpaid by 8 hours. So he filed this huge class action case. So if you can see why these cases are so expensive. Can you imagine how many Home Depot employees there are across the country? Could there be 10,000, 20,000? So if you multiply one person by 10,000 or 15,000 people, this is now a $9 to $10 million case. So these are huge cases. And Home Depot had a time clock. So they didn't write their time down. They recorded it on a time clock, but they also rounded. And so Kent realized that he was cheated out of 8 hours. And Home Depot says, excuse me, we're allowed to round. The Supreme Court says rounding is legally permissible, and they won at the trial court. And the Court of Appeals looked at this and they said, no, they reversed it. And this is their reasoning. They said, look, the times have changed. Back in the olden days, we kept a piece of paper and a pencil. And for HR to figure out the exact time people worked, was just a terrible administrative nightmare. So we allowed rounding. In today's day and age, we now have a time clock. And the time clock has a computer system, and it can calculate the exact number of hours and minutes that the employee has worked. So it's doing all that work for you. And what the Home Depot case is saying is, if you have an electronic time clock, you should be paying them for the exact number of hours worked, and you should not be rounding. And so I just want to warn you that if you are using an electronic time clock for timekeeping, you should no longer be rounding your time. You should be paying for exact hours. If you're keeping a paper time card, you are still allowed to round. So that is this is the effect of this case is just that. Okay. This next case is called the Kadena case, and I'll just go over it very briefly. I was going to call this case booty time, but the real issue is these call center workers want to be paid time for booting up their computers. Yes. How many seconds does it take to boot up a computer? They wanted to be paid for it. And they also wanted to be paid for shutting down the computer. And the employer, when they got this lawsuit, they said, look, we shouldn't be paying for booting up time, because booting up time is the same as waiting in line to punch in a time card. And we know that standing in line to punch in a time card is not compensable. So they said booting up a computer is the same as just standing in line to punch in a time card. And the Court of Appeal says, we disagree with you. We believe that the time it takes to boot up a computer is compensable because these are call center employees and they cannot do their job until they boot up the computer. So they found that booting time is integral to being a call center employee, and they said, you need to pay them for that time. It is not the same as standing in line in front of a time clock. But the court then said shutting down time is not compensable because you're not required to shut down the computer to answer calls. So just be careful if you have computer employees, that maybe you should ask them to clock in first and then they turn on their computer. So this next case, for those of you who are private employers, and you now have arbitration agreements, this case called Espinoza, this was an employee that sued her employer, a skilled nursing facility, for discrimination. And what happened was, once they had an arbitration agreement. So once the employee goes to, let's say, AAA, and they say, we want to make a demand for arbitration, they will send the invoice to the employer, and they will give the employer a certain number of days to pay. Well, guess what? There's a new law in California, and the new law says, employer, if you don't pay the arbitration fee on time, the employee can now bypass arbitration and go straight to court. So that's your incentive to pay the arbitration fee on time. And this case is basically saying that, which is you need to pay the fee on time. And if you don't pay the fee on time, they can now go to a court of law. Okay. This next case is on age discrimination. It is our last two slides. And it really deals with what kind of evidence can you use to prove an age discrimination case. So Joan Opara was terminated from the IRS because she was accessing taxpayer data without permission. Once they terminated her, she sued for age discrimination. And her evidence of age discrimination was that the person that terminated her made ageist remarks. And by the way, in court, when the decision maker makes the discriminatory comment, it actually is direct evidence of discrimination. And the trial court granted summary judgment for the IRS. And what they said was, even though she had direct evidence of age discrimination, she submitted her own affidavit as to what this person said, and without a witness to also hear it, the Ninth Circuit is saying, we no longer find that type of evidence credible because you are giving us a self-serving declaration. So if you no longer have witnesses to the ageist remark, then you're going to have some issues with this proving this case. Okay. The second to the last case, it's a case about a supervisor's off-duty sexting with a coworker. So there's some lessons to be learned in this case. So, okay, there was a pharmacy student named Haneen, and while she was a pharmacy student, she shadowed a pharmacist at Rite Aid, and they became friends. And once they became friends, they would text each other and talk to each other on a social basis. Then Rite Aid decided to hire Haneen as a pharmacist. Now, Haneen was working for Eric, the pharmacist. So they're still friends, they're still texting on a social basis, but now Eric is her supervisor, whereas before she was like a resident intern. So Eric, who was off duty, sent Haneen a text of him engaging in sexually inappropriate conduct. And then he says to her, I am so drunk right now. Then he realizes that he sent the photo to her, and then he tries to fix it by saying, I meant to send this to wifey. So he made this huge mistake. A few days later, she has an attorney sending Rite Aid a demand letter, and then basically she quits. And then Rite Aid terminates the pharmacist, and then Haneen sues Rite Aid for sexual harassment. So here's the issue. Here is the issue. The pharmacist did the texting not at work, but he was off work, off site. And the question is, was he engaging in sexual harassment of this subordinate, even though he was doing it off work and off site? And the trial court granted judgment in favor of Rite Aid. And at the Court of Appeals, the Court of Appeals says Rite Aid wins because there was no evidence that the pharmacist was acting as her supervisor at the time of the sexting. And what they reasoned was that the two of them were friends. They were friends outside of work. They were friends before she got a job. He was doing this outside of work. And because they had a personal relationship, it looks like the two of them were just engaging in a social texting relationship. And because of that, the appellate court said it basically looks like two friends were talking to each other. So here is my practice tip to everyone. Drinking and texting is a bad combination, and I really don't recommend it. So that is the moral of the story. Okay, so here is my last slide. I call it Music is Harassment. And the moral of the story is this legal theory called equal opportunity harassment. So the backdrop is there's a legal defense called equal opportunity harassment. What is that? You are not engaging in harassment if you're mean to men and you're equally mean to women. So you're called an equal opportunity harasser. You pick on men, you pick on women. There's no sexual harassment. I'm not picking on women because I pick on both genders equally. And that's actually a defense. So the advice I've given is if you're going to be a jerk at work, make sure that you're mean equally to both genders. So in this case called Sharp, Sharp sued the employer because this was a warehouse and they had a forklift, and the forklift went up and down the aisles, and they had a speaker box on the forklift. And as it was going up and down the aisles, it would blare these very offensive music, and it offended both the men and the women. And this forklift would just go up and down the aisles. So the female sued for sexual harassment. And the warehouse said, we're not harassing you. We are equally harassing both sexes. So how can we engage in sexual harassment if we're blaring the music equally at both men and women? So there's your novel theory of equal opportunity harassment. And the Ninth Circuit, got appealed to the Ninth Circuit, which is in Pasadena, and they reversed, and they said, look, the music does not have to be directly targeted at that particular female. What's important is when that female employee goes to work, she is being repeatedly exposed, prolonged exposure to music with sexually derogatory content. So the mic or the speaker did not have to be directed to her. The very fact that she's at work and she has this repeated exposure to sexually derogatory music, they said this is enough to make it harassment based on sex. So she had standing to sue this warehouse for sexual harassment, even though the conduct was not really even directed towards her. So what's the practice tip? The practice tip is make sure you have some pretty boring elevator music in your warehouse at all times. No, be careful of your background music. You want to make sure that it's neutral. Be careful of the posters, anything that people can hear and see in the workplace, the photos that you put up in the workplace, even though it's not directed at anybody, if it's offensive, you have to be careful. It could constitute some form of a hostile work environment. So we are at the 7:19 hour, and that is it. And I'd like to open it up for any questions that you might have.
Kristine, I have a question. On the last case, the trial court dismissed, and that seems odd to me that sexual harassment is either one party or the other. I mean, one gender or the other gender. Why can't it be sexual harassment over everybody? And then it was appealed, and they didn't address that issue. It was a whole different issue on the appeal.
You are absolutely right. And in fact, there's a Ninth Circuit case out of Las Vegas where this was exactly the issue, where a pit boss in a casino called women the B word, and then they called men the A word, but only the women sued. And the casino's defense was, the guy's just a jerk. He's not engaging in sexual harassment. But the Ninth Circuit said, no, you're wrong. Because you used the B word towards women and the A word towards men, you are actually engaging in sexual harassment with both genders. So you are absolutely correct. The main the difference could be in this case is maybe the lyrics were gender specific. And they weren't directed towards men. It wasn't sexually related comments towards men. It could be only directed towards women. And the warehouse's defense was, how can we be harassing her? It's just music that is being played in the background, and it's not really targeting her. And the court said, it doesn't really need to target the person, because when an employee comes to work, they are entitled to a hostile-free work environment. And if they're being exposed to content that is sexually derogatory or racially derogatory, then that is the basis for the claim.
Thank you. Thank you.
Sure.
Other questions from our guest tonight, for our guest tonight?
I have a question. Can you hear me?
Yes.
This is Tina Sue, Very nice presentation. Thank you so much, Kristine. I had a question about the initial thing you were talking about, sick leave, and I didn't understand how we are meant to indicate the sick leave on the pay stub at the beginning of the year.
Okay, so as you know, there are two formulas for sick leave. The first formula is the front loading method, where you front load 40 hours at the beginning of the year. So if you're going to do that, then at the pay stub for your sick leave balance, it should say 40. And then as they use their sick leave, the following paycheck stub should have the sick leave balance. The other way of managing sick leave is called the accrual method. It's a formula. It is 1 hour for every 30 hours worked. So if you have somebody that is working 160 hours a month, which is a typical 40-hour work week, divided by 30, that's 5.33 hours of sick leave per month. So on the sick leave, on the paycheck, that monthly accrual should be reflected on each paycheck. So you have to keep a running tab of the sick leave balance, along with vacation and other things.
I see. And so if what happens, I suppose, if you have an employee who stops working for you and you've already put this sick leave at the beginning of the year and they quit at like 9 months or something? I'm just making an example.
There is no cash out provision at all. So you don't have to pay them out. I think in the law, it says that if they're rehired within like a year or something, you need to reinstate a portion of that sick leave, but there's no cash out. However, I do need to warn you, if you use PTO instead of, if you have a policy at your work that everything is called pay time off, for example, then if you have an accrual formula and you can use it for sick, vacation, for whatever you like, then the law will presume that that is vacation pay, even though you allow it to use for sick leave. And if they quit, you do need to cash them out. So if you don't want to cash out people, then have a sick leave policy. There's no cash out. Your vacation policy, you do have to cash out.
Okay, so they basically want us to indicate on the pay stub what is sick leave and what is vacation.
That's right.
Okay, thank you.
Sure, you're welcome.
Other questions tonight for Kristine? Well, hearing none. Kristine, that was a fabulous presentation. Very, very interesting. Thank you so much for being part of our program tonight. And
you're welcome. Thank you for inviting me. It's such a pleasure.
It is. All right, so I'd like to remind everybody, our next meeting will be in March. It'll be another Zoom meeting. Our first live in-person meeting will be the Huntington Library in April. We're looking forward to Randy presenting that night, and should be a wonderful event. It'll be an opportunity for everyone to get together in City Club, and I'll look forward to seeing everybody there. So with that, I wish everybody a good night and have a good evening. Thank you. Thank you for joining us tonight. Kristine, thank you again.
You're welcome. Thank you. All right. Bye-bye.